recommend I start off.
Good evening. Thank you for joining us on Facebook Live, our English edition this Tuesday, reminding you that on Thursdays, 7 p.m. West Coast time, it's in Spanish, en español los jueves. Very nice. I'm hearing Jose, sorry. Breaking news. I have Jose with breaking news. Continue. Fine. Sorry about that. I hear from other sources, and there was breaking news, and I thought I had to stop. I apologize. Anyway, let's go into our topic today. DACA. DACA today is their anniversary, as many know. 5 years of DACA for Dreamers. It started in 2012. It was an executive order issued by President Obama. And today marks the 5th year that many, almost 800,000, maybe more, applicants, dreamers, have benefited from this program and have Social Security cards, driver's license, and work authorizations. Many have been able to travel to their home countries and enter legally into the United States with advanced paroles. So that's the wonderful part of it, the part that we're celebrating. However, I have to be honest with you, there's still talk in the administration of perhaps eliminating the DACA program. So unfortunately, unfortunately, there is still talk of maybe ending the program. Nothing official yet, but there isn't anything official saying that they're going to protect and support and continue to sponsor and fight against DACA being eliminated. So that's the bad news. Unfortunately, we have to heed to the bad news as well and be prepared, which is what I always say. It's not just to sensationalize the bad news. That's never my intention. My intention wholeheartedly is to share what's going on so that we can better prepare. Now, many dreamers do have relatives that are lawful permanent residents or citizens. Maybe they have a parent that's a resident or a green card holder, as many people would say. However, they're married and the spouse that they're married to is also a dreamer. My recommendation for this family pattern would be for the mother or father to naturalize and become a U.S. citizen, so that then the parent can immigrate this young dreamer and later get them a green card because now they're U.S. citizens. That's one way. Sometimes they're married to a resident and they're thinking, oh, it's going to take forever, many years, I may as well just stay with my DACA. Maybe that resident can become a citizen as well, and the spouse can later immigrate the dreamer in a matter of months if they've had advance parole, or in a matter of a year if they're going to go abroad. Or maybe they have a sibling that's a United States citizen that's about to turn 21. Well, that sibling, U.S. citizen, can later petition for the DACA dreamer. Very important for me to underscore or really emphasize is that many dreamers believe that they can only have one process at the same time, i.e. have their dream application, their DACA application, and they don't realize that they can have another parallel application, or maybe even two at the same time. Maybe they have a sibling that's a U.S. citizen and a parent who's a U.S. citizen. They can file both applications and continue with their DACA. They don't crash with one another. So it's important that those that have other alternatives seek advice so that they can look and see if that's an option that might be beneficial for them. Also, many dreamers are still asking, should I renew my DACA application? Yes, you've already been applying for several years. You're not going to give them any more information or new information that they didn't already have. So it's important that you continue with your application and continue to renew your application. Also, many dreamers are saying, my little brother, my little sister just turned 15, and they came in at the time that the law requires, and they're in high school, and they're eligible, they don't have a criminal record. Should they apply? Well, that's a difficult question to answer in a general way for me. However, I've talked to the parents of these young children that are turning 15 and are eligible for DACA, and I've talked to the child as well, and I explain the benefits and I explain the risks, because if this program ends, of course, you've turned in all that information for this young 15-year-old, and maybe you've turned in information to get nothing in return. So that is a risk as well. I also remind you that there have been proposals in Congress for things that would bridge a gap between DACA for dreamers, and if it were to be eliminated, give them something new, which is the Bridge Act. So perhaps you want to apply as a young 15-year-old because you're thinking, well, if I apply for this and get a benefit and then it's canceled, if the Bridge Act becomes a reality, I will be protected by that new act as well. So many considerations to take into account, and I always recommend that you not talk to your neighbors, talk to your friends, talk to your family, but don't make a decision based on that. Seek the advice from an immigration attorney to see if in your particular case it would be a good idea or not. So very important for dreamers. Also, the last question I'm getting a lot in my office, I remind you that I practice immigration law and I've done so for 30 years. So I get a lot of questions from many areas and many different facets that help me share with you here on Facebook Live. Another question is, should my son or daughter, or the young dreamer asks, should I travel back home? I do have a relative that's very ill, and should I go? Will I be allowed back in? Well, that depends on when you're going and if they change or turn down or break down or eliminate DACA. You don't want to be out of the country with an advance parole to come back in and maybe not be able to come in. So I'm strongly recommending, if you have an emergency and you have to go out and you're a dreamer and you have DACA, to go quickly. Don't, spread it over a span of 2 weeks. Go over a weekend and come back. In case they're going to eliminate DACA, you can be allowed back into the country. And the benefits of that are twofold. One, that you see your relative that you obviously love and that you want to see, and if they're very ill or they're dying, see them for a last time. And two, the benefit of coming in and having a legal entry in your background, in your history. Then later you marry an American citizen and that person can immigrate you because you came in with an advance parole in a matter of months, all within the United States, without having to go to the American embassy in your home country and without having to ask for a parole or not a parole, a provisional waiver, which is a pardon because you've lived here illegally. So there's many benefits to going out and coming in, but again, I strongly recommend you seek immigration counsel before traveling out of the United States with an advance parole, because some people have priors, whether they be criminal priors or immigration priors, that could affect your re-entry. So all of this to say, congratulations to all the dreamers that have radically changed their lives because of DACA. I'm so happy that people have taken advantage of this program, 800,000 or maybe more. And yet the bad news is that we don't know how long this program is going to stay, continue, or if it's going to end. So that's where we are right now with that uncertainty. And of course, here every Tuesday and Thursday in Spanish, I will be reporting what I'm hearing. I'm also a member of the American Immigration Lawyers Association in Washington, D.C., so we get a lot of information and feedback from what they're saying in the Capitol about DACA. And as soon as I hear, good or bad, I will be sharing here on Facebook Live. Let's go to questions. Spanish. Why do we have this segment on Tuesdays in English? Not because I only speak English. Hablo perfectamente el español. We have this because we want to attract and we want to help those that only speak English as well. Así es que les recuerdo, en español 100% los jueves a las 7 de la noche costa oeste y a las 10 de la noche costa este. Todos los jueves, ya llevamos casi un año y los números fenomenales. Gracias por que nos siguen, gracias por su sintonía, gracias por su confianza. Compartan que los jueves es en español, pero los martes hay muchos jóvenes que no hablan bien el español y que prefieren en inglés poderle ayudar a sus padres, a sus hermanitos, a sus cónyuges, y por eso tenemos los martes en inglés. All that to say that Tuesdays in English, Thursdays in Spanish. Let's go to questions.
All right, the first question is from Charlie. Do you recommend to self-apply for the DACA renewal?
That's just what I spoke about, Charlie, but perhaps you were busy typing and didn't hear me. But I did say that, yes, those that do have DACA and are dreamers should continue to renew. I'm kind of going out on a limb here, but I don't think that renewing will hurt you. Those that want to apply for a first time have to consider it, however. But those that already have their fingerprints in with USCIS, that have all their information and their data of where they work, where they live, their family's information, you're not giving them anything new by renewing. And my concern is if you don't renew and you fall out of status and they do eliminate DACA, and then a Bridge Act comes or something else that will help these young people, if they may say, well, wait a minute, you let DACA lapse, so you're not eligible for a new program. So I see that in a balance, that the possibilities of there being something in the future outweigh the risk of renewing. So I would renew if you've already applied in the past, Charlie.
All right, the next question is from Nancy. I'm a U.S. citizen but have a 10-year-old son in Mexico. What's the fastest and easiest way to bring him to the U.S.?
Nancy, you being a United States citizen, of course you can petition for your child. Because he's a minor under 21 years of age, you can immigrate him relatively quickly. Now, I don't know if the child, if you've been bringing him back and forth and maybe has a visa, then he might enter with a U.S. visa, and then later you can change his status and do a green card here. If he has no visa, no passport, he's never come to the United States, you can apply. The application is an I-130. You file it with immigration. It takes a few months to get approved. Then you're going to get correspondence from the National Visa Center, forms to fill out, fees to pay, and then you'll get the final interview. If your child is Mexican, he will go to Ciudad Juárez where you can join him. He'll have an interview, which will be very brief, and he'll get a green card in a matter of months to a year max. So you should start that process soon. We don't want him to age out. As he grows older, laws change, so you want to do this as a minor as soon as possible.
Carla, if my brother is a Marine, can he help my mother have legal status here?
Wonderful question, Carla. If your brother is in the armed forces, whatever it is, the Air Force, the Marines, Army, by being in the armed forces, President Obama issued another executive order that said, For parents that are undocumented in the United States that have children over 21, if they serve the nation in the armed forces, they can give their parents what is called parole in place. This is still on the books. It hasn't changed. So far, no threat of it being eliminated. And now, I don't know, Carla, how old your brother is, but if he's between 18 and 20, he can request the advance parole for his parents. He has to wait till he's 21, and then at 21, he can immigrate his parents. So it's a two-step process. First, parole in place, showing that he's in the military. Your parents would have documents that allow them to be in the United States. They cannot be deported. It's somewhat of a permit. And then when, I don't know your status, Carla, but if you're over 21, it could be done two-tier. Your brother gets parole in place for your parents, and you, being over 21 and a citizen, can petition for your parents immediately, all within the United States, without having to go to any American embassies abroad and risk not being approved and have to stay out of the United States.
Luis Carlos, if I applied for a visa U since 2014 and I haven't received anything yet, does it usually take that long?
Yes, unfortunately, the amount of people applying for the U visa has increased over the years, I've noticed. When I first started doing U visas a few years ago, 6 months they'd get a U visa, a year max. Now it's taking 3 years, even 4. I remind you that there are only 10,000 visas issued per year. And unfortunately, in front of you, there may be 30,000 people waiting their turn as well. So you'll have to wait your turn, and when that happens, you will be issued a U visa. 3 years later, you can get a green card. So it's a process. Certification first, the U visa, and later the green card. Best of luck.
Maribel, if a brother that is 23 years old and is a born U.S. citizen, if he's here in the U.S., can he help his older brother that's 34 years old and is not married, has 3 kids, and is a DACA beneficiary? Is there any way that he can help him obtain his resident card?
Definitely. The petitioner, in this case, the 21-year-old U.S. citizen, can immigrate siblings, parents. The age is irrelevant. So a U.S. citizen over 21 can petition for a little sibling that might be 10, or you can petition for an older brother that's 30-something, like in this case. Now, the waits are long. For Mexico, it could be up to 20 years. And for Central and South America, they're in 04, so that's 13 years. It's still a long wait, but at least they have something filed, and eventually, hopefully, they'll be able to immigrate. There are issues of illegal presence if those that are getting the green card are in the United States illegally and they're adults, but we never know. By the time they get a green card, there may be other laws that'll benefit them. But it's the age of the person that's going to get a green card is irrelevant as long as the petitioner, the U.S. citizen, is over 21. Great question.
Thank you so much. The next question is from Jessica. I applied for a resident card 5 years ago, but I lost it, and I applied for a replacement card. Am I in trouble?
Not at all, Jessica. The only issue I see for you is, let's say, I don't know where you live, what state, but if you were in a checkpoint area where ICE has presence, or you're in a border area, or you want to travel, or you want to immigrate someone, well, you don't have a card that states that you are a green card holder. What I do for all of my clients, I make a copy and I scan it of their green card, both sides. Then if they lose it, it's easy to replace because we have all the information and all the numbers and codes that are necessary to file an I-90 application. And I recommend that everybody have a copy at home of their green card. Now, a copy, if you see ICE, is not going to quite cut it, but at least it has your number, your A number, which is a number that you are identified by for immigration purposes. And an officer can check and go, oh, yes, Jessica, you are a green card holder. You have to renew it, make sure. And I would also carry, Jessica, a copy of the receipt when you filed for a new replacement, which is the I-90 application. Immigration will send you a receipt, and that receipt should be carried with you. This way, if you're stopped, it'll have a lot of codes and numbers that tell the officer that you are a green card holder. I would not travel with that document, and I wouldn't travel out of the U.S. If you need to travel, get a passport from your home country, go to immigration, and they'll stamp a temporary stamp on your passport so that you can go in and out while you get a new card.
Rozier. My friend was assaulted a few weeks ago, but the person ran away. We have the police report, and I wanted to know if that's enough to qualify him for the Visa U. This happened in Atlanta, Georgia, and he has TPS from Honduras. If so, what are the requirements?
Very good. It's hard for me to say if he qualifies or not, Rocher, and thank you so much for coming online and asking for a friend, and that's what I encourage all of you to do. If you have a relative, a spouse, a friend, someone you love, and you speak English and you want to get on these Facebook Lives on Tuesday and ask questions, I'll be happy to give you general information, and thank you for doing that for your friend. Now, you say that he has a police report. Very important, and I'm so glad you're making this question as well. People think that, oh, the bad guy got away, so I don't qualify for a U visa. I was hit, I was hurt, they did some kind of crime that qualifies within one of 31. There are 31 crimes that qualify for a U visa and derivatives of these. So some people think, well, the bad guy got away, they never got him, the police never called me back to investigate or do a lineup check or photograph check. That does not matter for a U visa. If you reported the incident and qualify under one of these 31 crimes because you're a victim of a violent crime enumerated by the laws, you qualify for a U visa if you reported it and there was a police report. Now, there are 3 phases, as I said in the earlier question. So the first phase is you must go to the police and have them sign a certification. Then after that, you go in and file your U visa. Now, you do have temporary protected status. You said he's from Honduras, your friend. So you're kind of getting the same thing. You're getting a U that gives you the same benefits as TPS. However, temporary protected status in most cases does not become permanent residence. And there's a threat, there are rumors that they may eliminate it. So I would definitely try to get a application file for a U visa and seek counsel to make sure it's a valid one and that you qualify and that the crime that you were a victim of qualifies under the enumerated 31. And then I would consider filing, even though it's giving you the same thing, but TPS does not become permanent resident and U visa does.
Thank you so much. The next question is from Patsy. I renewed my DACA and I'm waiting for it to arrive, but I'm married to a U.S. citizen. Can I apply or do I have to wait for DACA? I also have an ill daughter that has a health condition. Will that help in any way?
If you were detained and you had no status, yes, having a child born in the United States with some kind of illness or some kind of physical need that requires you to be here with your daughter, of course that would qualify for not a green card, but at least fighting a case in immigration court and defending yourself in case and against a deportation. However, you have DACA, so nobody's going to want to expel you from the U.S. You're married to a United States citizen. I would definitely file for a green card through your spouse. And the fact that you have DACA does not crash in any way. On the contrary, it may help you. And if you've traveled and come back in, you may be able to finish the case through your spouse that's a U.S. citizen in the U.S. And if you've never traveled and you don't intend to travel, then you'll have to go to your home country to get your green card at the end, and you'll have to request a waiver for living here illegally. Now, I don't know how old you are. Maybe you got DACA when you were 18 and you have no illegal presence. Then it's a much simpler case.
Matilde, I have a 245I protection and my son is a Marine, but I got deported once back in 1996. Is there any chance that I can get any statues? My son is a U.S. citizen.
Wow, you say deportation, Matilde, and I always cringe when people say deportation because that word is used so loosely and it might have been a voluntary departure and it might not be a deportation. First thing I would do if I was your lawyer, Matilde, is send you to get fingerprints with the FBI. I'd request your record from immigration, or if you have any copies of this incident in '96, I'd want to see them to see if in fact it was a deportation. If it was a deportation and you re-entered, there's trouble, even if your son is in the Marines or your son is a U.S. citizen and you have 245I. Many people confuse 245I. They think that that's a way of getting a green card. No, it just allows you to get your green card in the U.S. However, if you've been deported and re-entered, when you go to the immigration office within the U.S. to immigrate through your child, who's in the Marines, they may arrest you because you've been deported and you re-entered. So you need to do a lot of work before you filed, and thank you for writing us, because hopefully I've encouraged you now to go see a lawyer and take all that information, your son's information, the 245 information, the so-called deportation, so that an immigration attorney can put it all together, this is a puzzle, and tell you which route or no route at all. So you want to get advice before you even start and pay anything.
Angel, I was banned from the U.S. and I would like to know if I can come back to the U.S. border on a border crossing card.
You don't tell me why you were banned, Angel, if you were deported, if you've committed a crime, if you've had multiple deportations. I don't know. However, if you can get a valid border crossing card, now let me retract. If you had a border crossing card, Angel, before you were banned, I'm quoting you, no, you cannot use it, because when you cross, they're going to run that card and they're going to see that it's no longer valid because you've been deported. Now, if you get the card after you were banned and you are now asking to come back in and it was issued and you told them the truth, you told them you were banned, you didn't lie, you didn't change your identity, and the embassy is now giving you permission to re-enter with this border crossing card, of course you should come in. But I would need to know a lot more, and I would not come in if it was issued before the ban, because they're going to know when you try to come in, they scan everything and they're going to say, wait a minute, Angel, you were banned and this card was issued before, no longer has any validity. So again, go see an immigration attorney, show them everything, the ban, the border crossing card, so that they can tell you if you should or not attempt a re-entry.
Edith, I have a question. My mom, who is 73 years old, wants to apply for her citizenship after 7 years of residency in the United States. She has a hard time learning English. I'm wondering if my mom can get a doctor evaluation to skip the English exam. If she asks for reduction of payment on her N400, her process will take longer.
Okay, there are many questions here, but Edith, thank you for asking questions. And again, that's why we do this at Telemundo. Many ask, why is it in English? See, Edith can now ask something that maybe her 76-year-old mother would not get on Facebook Live, doesn't even know what Facebook is, let alone how to engage with Facebook Live and ask questions. Yet Edith is probably a millennial or a young woman and now can ask questions in English and then tell her mother what to do. So thank you for being there and helping your family in this English version of Facebook Live. Now, Edith, the first thing, your mother is 76. Unfortunately, she's not a resident for a lengthy period of time. People that are elderly can take the exam 100% in Spanish and even an easy version with only 20 questions, but she has to have been here for 20 years or more as a resident, not out of status, and be over the age of 50, or be a resident for 15 years and be over the age of 55. So she has the age element, but she doesn't have the green card for the amount of time that the law requires to take the exam in Spanish. However, because she is over 65, she can take an easy exam. There's 100 questions to learn for citizenship, but there's 20 for people over 65 that are really simple, but they are in English. Now, if she's unable, just impossible to learn English because of her age, because she may have some mental issues like dementia or Alzheimer's or beginnings of, definitely she can get a medical evaluation, and it has to be very documented, very detailed and documented. I see people filing these waivers for medical waivers, and the doctor just puts a code and dementia, lack of ability to memorize. That's not going to cut it with immigration. They want like a full story. That's where a lawyer helps you, works with the doctor, works with your mother, works with immigration, and presents a story to immigration besides the medical evaluation that says this person is impossible, cannot learn, and really wants to be a U.S. citizen. And I've been able to achieve and accomplish these waivers for people in similar or even older ages. So it does happen. So don't give up, try, but you and the doctor or your mother and the doctor have to work really closely together so that it's almost a story, not just a line of why they should give the person a waiver, but a full explanation by the doctor. And that's where the doctor and the lawyer work together. Best of luck.
Thanks so much. And this next question, it's a few questions in one. So it's from Yanina. Can a dreamer be married to a military? can the military ask for the parole in place, but the dreamer had a deportation in 2001. This deportation was never given to the dreamer because the dreamer was 14 years old. Now, being a dreamer, it shows that deportation and it is on file, but it was never addressed. What do you suggest?
Never addressed. I'm not sure about that. Again, Janina, this not because I don't want to help you or don't know the answer. I need to see all these documents. I need to see the DACA application, make sure that this was revealed. Many people apply for DACA and they do it on their own, or they do it through a friend that helps them fill it out. They don't quite understand the questions and they don't reveal a prior deportation, and you get the DACA issued because immigration didn't find out, and now you want to do something else and they'll say, wait a minute, you didn't tell us when you did DACA that you had a prior deportation. So we got to put it all together. The DACA, look at the application, the so-called deportation, and then decide if you're going to apply for a green card or not. Many people are married to United States citizens, and unfortunately I have to tell them, don't even get close to filing an application through marriage, because you're going to be sent out of the country to immigrate, or you're going to go to the interview in the United States because your husband's in the military, and you're going to get arrested the date of the interview. So I'm so glad you asked the question, because one, it's multi-layered, and two, definitely take copies of everything and seek immigration counsel to see if maybe, again, the deportation was not a deportation, it was a voluntary departure, and it was in a certain year. The laws have changed, and depending on the year that somebody was expelled out of the United States, it can have different consequences. So I would strongly recommend, before even filing an application through your husband, because when you file, Janina, you're giving them all your information. And later, if you want to stop, you can stop, but immigration has a full file on you. So I recommend that you seek maybe 2 lawyers and get 2 opinions before filing anything when you've had priors in the past.
A lot of inquiries as to see how our users or viewers can get in touch with you. If you can please share that information with them.
Of course, it's really easy. You just go to almarosanieto.com. You see, I guess right by my name, I can't see it, I'm looking at a black screen, but you can see almarosanieto.com. That's my webpage. It has my address, the phone numbers, how to make an appointment, how to make consultations all over the nation. We're happy to help you if that's what you choose. And I also recommend you seek AILA, AILA.org or AILA.com, AILA, and that is a nonprofit organization of immigration lawyers nationwide, because some cases require you to be real close to your lawyer, like if you're going to court. And some cases are all done over the mail, so whether I'm in Los Angeles and you're in New York or Miami or Seattle, it makes no difference. I can still help you, and I have a lot of clients that are even internationally. But it's almarosanieto.com, very simple. And please visit the website. We just revamped it. English version videos are being edited as we speak, and I'm hoping by Monday they will be on. So subscribe to my website so that when the videos are live in English, we'll let you know, and you can peruse through the website, and hopefully some of those videos will be of use for you.
Thank you so much for that information. And the next question is from Adelita. My DACA expires in January 2018. I'm hesitant to renew because of the new lawsuit in Texas. Should I renew or wait until after September?
Well, you said it expires in January. Now, I've had 2 experiences, Adelita. I just renewed for one of my dreamers, and it took 5 weeks to get the renewal. I was shocked when it's taking 5 months to 6 months to renew. So in some cases, if they're well prepared, they're super clean, nothing's really changed, the officer's kind of on the up and up, and they're not dragging their feet, they're approving them very quickly. And some are taking up to 6 months. Now, if you are going to wait till September, you still have most of September, October, November, December, 4 months. So if you want to save money, yeah, I would say just wait. We're talking about the first week of September. We'll know what's happening, if in fact the 10 states are going to sue the government if they continue with DACA or not. You still have time to renew because your DACA does not end until January. So if you want to play safe side, I would wait. It's not going to prejudice you in any way. Now, if your DACA's expiring in October, I'd say don't, because it's taking so long to renew in most cases.
All right, and this is the last question. It's from Jackie.
Ready?
I know.
Time flies. I wish I could answer all of your questions. Jackie, tell me.
Yes, so the next question from Jackie is the following. My husband is Honduran. I'm a U.S. citizen. We're both married. I submitted an I-130 and I-212 in 1996. He got deported to Honduras twice for illegal entry, no criminal record. I would like to know which waiver I need to submit, if it's the I-212 or I-601. It's been more than 10 years. And as I said, he got deported.
Okay. Jackie, you gave me excellent information. Thank you. Very complete, except one thing. You don't tell me where he is. Is he in Honduras? He got deported. You met him. Maybe you live in Honduras with him because they see us worldwide on Facebook Live. Or he left and you met him there and you come and go to Honduras to visit him. If he's outside of the U.S. and he hasn't re-entered, then you can ask for an I-212 waiver. However, the I-601 waiver is for something else. There are many kinds and types of waivers. An I-212 is specifically to eliminate and pardon a deportation. An I-601 can be for fraud. Maybe he tried to come in several times and he used fake documents. He's going to need an I-601. Or maybe he's lived here after and he has illegal presence. He's going to need an I-601, maybe an I-601A. So I need to know more about where he is. And I also need to know how barred he is. When someone is deported, they're deported sometimes for 1 year, 10 years, 20 years, permanently. So we need to see his record, and the best thing is if he has an A number, that's like a social security number, but for immigration. Starts with the letter A and it's followed by 9 digits. That would be fabulous because then we can ask for his entire record of every encounter he's had with immigration, both in and at the border. And this way we can see his whole record and analyze it and see if you should pursue this application or stop. Or maybe there's another route for him. So get all that information, seek immigration counsel so that you don't spend money unnecessarily.
And I know I said that was the last one, but we have one of our users who has asked multiple times. His name is Manuel, so we're going to answer this question.
Of course.
My wife is a U.S. citizen. She is pregnant and is currently in the U.S. I'm in Mexico with an I-330 to green card. Can I apply for some kind of permit to be with her when my baby is born? The baby will be born in November.
Okay. There's no I-330, so I think you meant, Manuel, an I-130. So your wife that's a U.S. citizen is petitioned for you, and you're in the process of getting a green card and going to Ciudad Juarez to come into the United States legally. Now, you don't tell me anything about your history, Manuel. Have you ever been in the United States? Maybe your wife met you in Mexico and you've had a long-distance relationship. You've never come in illegally. You've never lived here. Then perhaps you can ask for some kind of visa, even a humanitarian visa, showing the embassy that you're married to a United States citizen, that she's pregnant, a doctor letter saying when she's due, maybe if she's had any complications during a pregnancy, saying they need you here because it's a complicated pregnancy. And the embassy may issue a humanitarian visa for you to enter, or even a tourist visa if you're eligible. But they will not issue a visa if you've had prior illegal presence in the United States, or you were deported, or you've come in and out. So I would need to know a lot more about your case. You can always try. I recommend don't seek counsel in Mexico. I know that there are immigration lawyers in Mexico, but they are Mexican immigration lawyers. They know about Mexican immigration law. Seek counsel with a U.S. lawyer so you can tell them a little bit about your background and see if it's worth for you to go to the embassy. It won't hurt you to go to the embassy, although you already have an application pending, and try to get a visa to come in and see your wife and your child when they're born or before they're born. However, it won't prejudice the application you have, but please be very honest, because if you go to the embassy and ask for any kind of visa and you don't tell them that you already are filing an application through a U.S. citizen wife, when you're ready to get your green card, they'll say, wait a minute, you came to the embassy and asked for a visa. We denied you, and you lied. We asked you if you had any relatives back in the U.S., and you said no, and you obliterated that information. It could prejudice you later for the green card. So be very careful and get advice before you go to the American embassy to request any kind of entry to see your child born in the United States. Best of luck. And I'm so glad you insisted. Thank you, Manuel. You see, people that insist, we hear it, and even though it's past the time, I'm still answering your question. And that's our purpose here at Telemundo in mind, to try to get as many questions as we have in this short period of time on Tuesdays in English for 30 minutes. Y les recuerdo que los jueves en español a las 7 de la noche, hora del Pacífico, 10 de la noche, hora del Oeste. And I just said, for those of you that only speak English, that on Thursdays we are live every Thursday in Spanish at 7 p.m. West Coast time, 10 p.m. East Coast time. Thank you again. Really appreciate it. Please share this information with family and friends. See you next week.